Here's a torts hypothetical that tests a fairly significant portion of the entire outline, and our examination of this hypothetical may give you some very practical ideas about how to think about these questions and how to even read questions for the essays and the multi-state. As we look at this question, we see that it is not very long. There are plenty of multi-state questions that are roughly this length, and as essays go, this tends to be sort of on the short side. Now, both for essays and for the MBE, I strongly recommend that you begin by looking at the call of the question. Take a look at the call here. What are Peter's rights against Jim, David, and Busco? And then, does David have any right against Peter? Now, as we think about this question, before we even read the fact pattern, we can see that there are 4 lawsuits in play. And we know that for each of these lawsuits, the plaintiff is going to have one or more theories of liability. And also, the plaintiff is going to have one or more prayers for relief. So, before we even read the facts, we can look at this call of the question, realizing there are 4 lawsuits, and we can break each lawsuit up into a couple of pieces, and by so doing, we can organize our thinking, and in cases of an essay, we can organize our answers fairly meticulously before we even read the fact pattern. So looking at this call of the question, we would be inclined to judge it as either torts or contracts or real property. But looking a little more closely, we see that we have a defendant named Busco. And a familiarity with the way that the material is tested will clue us into the fact that bus companies rarely appear on bar exam questions unless there is a negligence issue and the common carrier standard is being tested. Now, as we go through this fact pattern together and look at the language of the question itself, one thing that becomes evident very quickly is it's possible to put an awful lot of issues into a question without that many words. Now, looking at these facts, we can see fairly quickly just how artificial a question this is. This is not a question that has anything to do with the real world, except for the fact that it allows us to have to come up with theories of liability pretty quickly. As it turns out, this is a question that's much more about the theories than it is about remedies. The remedies pretty much boil down to damages, and we look at compensatory and punitive damages within that. So let's take a look at how this question is written, and then we'll take a look at the outline of issues that I suggest. Look at paragraph 1, and we meet our plaintiff, Peter. He is a patron in a restaurant, and he leaves his wallet containing $100 on the counter, and he walks away. Jim is the restaurateur. He observes the wallet on the counter, but look at the language. He neglected to call it to Peter's attention. And we know Jim is the first defendant. So in so many words, the question tells us what the theory of liability is. Peter is suing Jim for negligence. And we also know that Jim is a restaurateur, which means that he owes that higher than ordinary standard of care that restaurateurs, innkeepers, and common carriers owe to their customers. So we know that at common law, for non-innkeepers and common carriers, there's no duty to warn. But here, there is, because the relationship between a restaurateur, an innkeeper, and a client, a customer, is one that requires that the innkeeper warn of a problem such as this. So, right after Jim neglects to call the lost wallet to Peter's attention, David, another patron and the second defendant, picks up Peter's wallet by mistake, thinking it was his own. That's a trespass to chattels. Not because that is not taken away by the fact that the wallet was picked up in error. The wallet was still picked up deliberately by David, and therefore at the end of paragraph 1, Peter's theory of liability against David will be for trespass to chattels. Go to paragraph 2. David is leaving the restaurant. Peter sees the wallet in David's hand and recognizes it as his own. Before Peter could call out, David boards a bus owned by Busco. That's our third defendant. Peter followed and managed to board the bus just as it started to move. He skinned his knee in so doing. Well, hang on a sec. Suppose you are sitting at the curb and I, a private citizen, pull up and offer you a ride. and you get into my vehicle as I start to move it. Well, just as a common citizen, that would be a careless act by me, the driver. Here we've got a bus driver who is a common carrier, once again, owing a higher than ordinary standard of care, and this bus driver is pulling away while a passenger is trying to get on the bus. We know that's an act of negligence, and we've got an injury, a skinned knee. So the plaintiff has got a theory of liability against the bus company now for negligence as well. Now let's pause for a moment. We've got 3 defendants so far, and we see that the theory of liability against the first and third defendant will be for negligence. We know the elements of negligence: duty, breach, causation, damages, and defenses. So we move on. We see the plaintiff, Peter, in the bus yelling, "Stop, thief," at David. Well, what do we know about David? We know David is not a thief. He did not deliberately try to steal the wallet. The last lawsuit, does David have any right against Peter? Well, it looks as if Peter's statement, "Stop, thief," is on its face a defamatory statement. And not only that, it's a per se defamation, because it is making a direct accusation of a crime of moral turpitude. Now, is there a defense to this claim of defamation? Sure. A reasonable mistake based on the fact that the plaintiff, here David, is in possession of the defendant, here Peter's, chattel. So the statement made by Peter is not unreasonable, but on its face it is defamatory, and that's the claim that David has against Peter. Was there a defamatory statement? Yes. Was it published to third parties? Sure. Everybody else on the bus could have heard this statement. Since it is a statement alleging a crime of moral turpitude, damages will be presumed. Have we got a valid defense here? I would argue yes, but the failure to discuss this issue or to understand the nuances of it certainly could cost a candidate a fair number of points in crafting a response to this question. Now we get to paragraph 3. David hears the accusation. He's angry about it. He says, "Don't call me a thief. Take your wallet and get out of here." He throws the wallet at Peter. As the wallet is flipping through the air, the plaintiff is the victim of an assault. It hits him in the face. That's a battery. Then the wallet flies out the window, and the trespass to chattels is elevated to conversion. Now, read on in this paragraph. Now the plaintiff, Peter, wants to get off the bus, but he doesn't have any money. His wallet just got thrown out the window. And the bus company operates its rides so that one doesn't pay until it's time to get off. So the bus driver argues with the plaintiff for a few blocks. What do we do with that fact? Answer: false imprisonment. Now, many of you are probably shaking your heads in disgust, seeing that the bus driver's conduct under the circumstances is not unreasonable. And I'm not telling you you need to find that there is liability for false imprisonment. What I am telling you is look at how densely packed the issues are in this fact pattern. Now, similar language is used throughout the multi-state and throughout the essays on bar exams all across the country. That's the nature of the exercise. So here, the lesson that we learn from these 3 short paragraphs in a very complicated torts fact pattern is it's easy to put plenty of facts into a very confined space that require an elaborate amount of analysis. Now, so far, none of the issues that we've had a look at are that difficult. But what makes this question challenging is how many issues there are. To write a thorough answer to this problem under time constraints, be it half an hour or an hour, would be fairly challenging, and one who is not well versed in the skills of issue spotting and outlining would have a severe disadvantage against somebody who is a little bit more clued in about how the material is tested. Now, finally, the bus driver lets the guy off, and he can't find his wallet. So then the tort of conversion is completed. Now, turn the page and have a look with me at the outline of issues that I've presented to go along with this question. And you'll see I'm not doing anything here that is remotely counterintuitive. What I'm trying to do as quickly as I can is identify the theory of liability, break that theory of liability up into elements, and then create in the outline a platform that will allow me to narrowly and specifically address all of the facts in the question. Well, this is not really a writing seminar. This is more of an issue spotting and substantive law seminar. But as we consider how we would write an answer to this question, clearly a question that is this densely packed with issues is a question that we probably will not have time both to do meticulous analysis and to write elaborate hornbook definitions. So, without turning this into an essay writing seminar, I would just remark for your consideration, if you have a problem making a decision about whether to write complete definitions or do thorough analysis, the correct decision throughout the country is put your emphasis on analysis. Okay, well, let's take a quick step back and look at this set of issues. With regard to Peter versus Jim, the theory of liability is going to be negligence. The breach is the restaurateur's failure to warn about the abandoned wallet. Now, we get to causation, and that's the most complicated part of this question as we think about it. Look at how this plaintiff has been injured. He's had a wallet converted. He's had his knee skinned. He suffered an assault and a battery. And all of these things wouldn't have happened but for Jim's negligence. So as we consider causation, is Jim the but-for cause of all of this plaintiff's injuries? Answer, yes. But is Jim the legal cause of all of these other injuries? Is the negligence of the bus driver foreseeable? Is the false imprisonment by the bus driver foreseeable? Is the assault and battery foreseeable? Is the ultimate conversion foreseeable? Well, to my way of thinking, there's no real correct answer to that question. One can write a fairly reasonable argument that liability should go all the way to include every bit of damages. And I think a credible argument can be made that this defendant Jim's liability ought to be cut off at the moment that the bus driver acts negligently. And perhaps one might draw a line somewhere in between those two extremes. The point of this seminar is not to tell you what the correct answer is. The point of this seminar is to tell you how best to organize your thoughts and how to analyze the questions at issue. Ultimately, my conclusion is the restaurateur is liable for the lost wallet and nothing more. But I'm a defense lawyer by trade and by inclination, both in civil and criminal court, so you'll probably get the impression as you go through these seminars that I have somewhat of a defense bias, both in civil and criminal court. I think that's probably true. But the issue here is not exactly what's perfectly correct, but what is complete and thoughtful. We turn to Peter versus David. He's got theories of liability involving trespass and conversion, and also assault and battery. I conclude that the defendant will be liable for the battery and for the conversion. Basically, my view is that the trespass to chattels will merge into the conversion, and similarly, the assault will merge into the battery. With regard to Peter versus Busco, we again talk about negligence, this time heightening the common carrier standard, and we consider false imprisonment as well. I conclude that Busco is liable for negligence. I let them off the hook for false imprisonment. A very reasonable and a persuasive response could be given that reaches the opposite conclusion. Finally, David versus Peter. With defamation, I rehearse the elements. My conclusion is the defendant prevails yet again because I think that the conduct of Peter under the circumstances is reasonable. His good faith belief in the statement that he is making, I think, is enough to absolve him of liability. And that wraps up a consideration of a question that, I think you'll agree, is very densely packed with issues. That's a classic type of fact pattern in torts, but we will see others that will focus our attention very narrowly on individual issues.